Okay, so my name is Thomas F. Coleman, and I'm the legal director of Spectrum Institute, which is a nonprofit organization promoting disability rights. And we focus heavily on guardianship and conservatorship reform. These are legal proceedings that implicate the rights of people with disabilities, including adults with developmental disabilities. And the presentation today is an overview of new federal rules that prohibit discrimination against patients with disabilities by healthcare providers who receive federal funds, which is most of them. So those rules were issued in May of this year, May of 2024, by the Office for Civil Rights of the U.S. Department of Health and Human Services, and they go into effect the first week of July, which is just coming up. So this presentation is timely in that sense that they're just about to go into effect. This particular presentation is being made to the Missouri Medical Rights Workgroup, which is a collection of individuals, self-advocates, family advocates, healthcare providers, doctors, dentists, nurses, social workers, regulators, and people from academia and also professional associations and trade associations. So, and disability rights groups. So it's a wide range of perspectives that are represented, in the work group. The work group was convened by AADMD, which is the American Academy on Developmental Medicine and Dentistry, by Spectrum Institute, and by the Alternatives to Guardianship Project of Human Resources, Inc., which was that project is partially funded by the federal government through the Missouri Developmental Disabilities Council. As I mentioned, the rules go into effect in July of 2024, and they're promulgated under two different statutes. One is Section 504 of the Rehabilitation Act of 1973, which generally deals with disability discrimination by entities receiving federal funds of all sorts, not just in the healthcare industry, although these rules are focused on the healthcare industry, and Section 1557 of the Affordable Care Act, which is otherwise known as Obamacare. So those rules were also issued in the last month, and they overlap to some extent. There's a lot of commonality between the two. I sent everyone a full report, a larger report, a 32-page document that explains in considerable detail how these rules apply to the healthcare industry and how they protect patients and enable family advocates and other advocates to advocate more effectively for the rights of this patient population. This is a screen share of the table of contents of that report. So you can see it's quite detailed, and it's available online for anyone that wants to review it or share it in the future with anyone. Today is going to be more of just a summary of the highlights, the key points. As I mentioned, the rules apply to providers who are receiving federal funds. And according to HHS, that means 100% of hospitals, 92% of doctors, and about 43% of dentists. Now, these are national statistics or data, but I'm sure it's probably something very similar in Missouri. So we're talking about, these rules apply to a very large segment of the healthcare industry. Now, in terms of data on patients in Missouri, This may vary by state, but in Missouri, there are somewhere between 200,000 and 300,000 adult patients with various types of developmental or cognitive disabilities that are not developmental in nature. And only 30,000 of these folks are in guardianships, which means that on a day-to-day basis, currently, and in the recent past, the overwhelming majority of adult patients with mental or developmental disabilities are making their own decisions in the healthcare services, either on their own alone or with a supporter or in some way, maybe through a power of attorney, but they're not in the guardianship. And speaking of the guardianship number, even though the legislature in Missouri added supported decision-making as something that's supposed to be ruled out before a guardianship is allowed in Missouri, that was in 2018, the number of guardianships is not going down. And in terms of, it's staying pretty much around the 30,000 mark, with about 3,000 new cases entering the system, cases being filed each year. So the intent, excuse me, the intent was to, presumably reduce the number of guardianships, but it's not working. And we don't know whether that's because it's not being considered, not being used, whether it's being ignored, whatever, but it's staying constant. And since the two primary drivers of guardianship proceedings is the healthcare industry and the schools, we figured that focusing on the healthcare industry and trying to educate patients, families, and providers about alternatives to guardianship might be a way of trying to protect the right of self-determination of people with disabilities, but also respecting the obligations and duties, ethical and legal duties of providers to make sure they have informed consent and that things are being done properly, that there's no abuse and so on. So it's a balancing act, but with a heavy emphasis on self-determination and rights. The other point that I make on this slide is that there are about 1,300 teens with developmental disabilities that are transitioning into adulthood annually in Missouri. So this is a patient population that the healthcare providers need to pay attention to, when the youngsters are minors, the parents are pretty much making decisions ultimately for them, even though they may be making it with them. But when the teen becomes 18, the teen has the authority unless they're in a guardianship. So, dealing with this transitioning is something very, very important in Missouri and elsewhere, and avoiding discrimination, stereotypes, prejudices, and generalizations is very important in dealing with the transitioning population with developmental disabilities. There are a variety of elements of the new rules that I'm going to talk about today. One is that discrimination is prohibited. Disability discrimination is prohibited. Decisions cannot be made about patient care or patient decision-making or release of information or any of that based on just mere diagnosis of a disability or based on assumptions or stereotypes or biases. Reasonable modifications must be offered by the provider to patients with disabilities who request the modifications, or if it's obvious that they need a modification. We'll get into that in more detail. Providers have a duty to ensure effective communication with patients, to them, from them, and just the exchange of information. It has to be effective. So we'll talk about ways in which that can be done. The providers have to provide meaningful access to the healthcare process to patients with disabilities. And that includes meaningful access to the decision-making process. We'll get into that in detail. Individualized judgments have to be made. It can't be just class-based stereotypes or assumptions or prejudices, as I said before. But if decisions are being made to restrict rights in any way, those decisions have to be based on the individual in question, the situation. It's situation specific. So we'll talk about that. Supported decision-making is now a part of the new federal rules and federal law. That was incorporated in a very significant way into these new rules. And so it's something that has been on the statute book, hidden in like the guardianship statutes in Missouri, but it's now something that healthcare providers and patients and their family supporters need to learn about and become familiar with. The law requires healthcare providers to have a compliance officer that assists them in obeying these new rules. There has to be a grievance procedure put in place internally by the healthcare provider so that patients that feel that their rights have been violated don't have to immediately file a complaint with the state or federal government, but they can file a complaint internally and try to have it resolved, with the least amount of conflict and in a speedy and fair manner. And there has to be employee training now of key employees, and we'll talk about what that means about these new rules. So those are the components of the new rules. With respect to discrimination, what's not allowed is denying or limiting treatment due to biases, stereotypes, generalizations, or the mere perception of disability, or refusing to allow the person to have assistance, the presence of a support person, or to engage in supported decision-making, or to exercise or use a valid power of attorney. What is permitted is to allow treatment decisions to be based on individualized assessments that are done by qualified people, and based on actual evidence of incapacity to consent. We'll talk more about that later. It's not just a general, they're incapable of making any decisions whatsoever across the board under any circumstances. No, it's got to be something more tailored. And judgments that are based on best medical knowledge are always permitted. They're also permitted to refuse to allow assistance by somebody if the patient objects to that person, because the support and assistance is always patient-driven. It's always the patient's decision. So if the patient doesn't want somebody in the examining room or treatment room, that person is not allowed in unless they're in a guardianship. Except that they can, if the patient doesn't object, but there is evidence that the supporter is being abusive or has been abusive, then that's a time when the provider can not allow that supporter to participate, but there's got to be actual evidence. And also, if there's evidence that a power of attorney is objectively invalid, well, then the provider isn't going to be required to honor that. So that's just the broad strokes on discrimination. As far as meaningful access, decision-making is always a central component of medical services, because providers have to obtain consent from patients before they can touch them or do something to them or invade their body with a needle or a probe, or or prescribe medication to them, etc. So consent is an important process. And the question is, what is meaningful access to the medical decision-making process? And there's kind of a spectrum of a scale of participation, and that always depends on the abilities of the person in question. So the most involvement is when the person makes their decisions independently, solo, on their own. Nobody present, no helper, just me. And many people, maybe most people with disabilities, have that ability. They do have the right to have a companion or support person present if they want. And so that is another level of support, or let's say of decision making, but it's not solely independent. It's the presence of a support person. Then comes things like supported decision making, where the patient is still making the decisions on their own, but with formal help in a way from their designated support person under a supported decision-making agreement, whether it's verbal or written, but they're entitled to have that type of support. Then the next is when the patient is not making the decision, but they have chosen another for circumstances when they are incapacitated and unable to make a decision, but they themselves have executed a power of attorney where they're saying, here's who I want to make decisions for me if a doctor decides validly that I am not capable of making decisions under those circumstances. And then finally, the least amount of meaningful access is when there's a guardian who makes decisions for the patient, and the guardian has been appointed by the court, oftentimes not even with the consent of the individual or the patient. So that's the kind of the scale. And so for a provider to give meaningful access, the provider must give the greatest amount of access possible without restricting rights that they can, unless there's evidence of incapacity or abuse or something like that, that requires the provider to restrict because they don't feel they're really getting informed consent or whatever. So, but automatically saying to a parent or someone else or a adult a child of an elderly patient, you've got to get a guardianship, go get a guardianship, then come back. That would be disability discrimination unless that recommendation or direction to the loved one is made by a qualified person, and that the process is scientifically valid, and we're talking about a specific decision that's being made rather than just globally, unless the person's in a coma. So the days of just recommending, oh, your kid's going to turn 18 in a few months, you better get a guardianship, those days are over, because if somebody tries to say that or do that, they're opening up the provider to a complaint of disability discrimination. In terms of, and we can come back to all of this and discuss any questions or comments that anyone has at the end. Reasonable modifications, under the Americans with Disabilities Act, but also under these two rules, under these two statutes that we're talking about, reasonable modifications are required. People often refer to it as reasonable accommodations, but the word accommodation is actually not used in this context under these rules. It's called modifications of your standard policies and procedures, and you're giving the person some additional support or help or assistance or technology or otherwise that wouldn't be given to a patient. So the provider is modifying their normal policies and procedures. But if you want to say reasonable accommodations, everyone will know what you're talking about, because that's the term that's generally being used, even though it's technically not correct in this setting. So for patients with developmental disabilities, that could require scheduling an appointment, or even someone, that's sundowns at a certain time or whatever, a senior, scheduling at a time or day when the person is functioning at their best. So, let's not schedule something for 7:30 or 8 o'clock in the morning if the individual is barely able to get out of bed or function or talk or whatever. So the scheduling is important. Extra time might be required, and probably will be required for somebody with developmental disabilities. So the normal 15-minute time slot may have to be extended, or you may have to reschedule for a second time slot to give the person time to digest the information, talk to others, and come back. Obviously, that would probably be required if the decision was of greater significance than something like, oh, you're going to get a flu shot, or I'm going to take your blood pressure or something like that. But if a significant procedure were involved, the individual is entitled to have a companion of their choice present with them for all communications, all procedures, unless it's something that would fundamentally alter the nature of the process. So they're not going to allow a companion in the operating room. So there are times and places when a companion will not be allowed, but that's done for very, important reasons. Simple language may have to be used. So, sometimes lawyers, doctors, others use technical terms and don't really consider the audience that they're talking to. It's like, wait a minute, doctor, can you like put that in plain English for me, or, boil that down to something simple. So using simple language is something that providers should keep in mind with people with developmental disabilities. Sometimes using photos or graphics. We've all seen in a exam room photos of people with faces from smiling all the way down to they're in extreme pain, and they ask you to point to the diagram that points to where you are in terms of pain or things. So those types of techniques and aids could be necessary to make sure the person understands what's going on. And then supported decision making, which we'll talk about more. But now we have 21 states that actually have laws that with supported decision making in state laws. And supported decision making, like I mentioned, it's in the federal rules that it's a requirement to be considered and used if feasible. So it's now a matter of federal law regulating the healthcare industry. In terms of individualized judgment, a mere diagnosis of disability does not equal a finding of incapacity. So somebody might, even have mild dementia, for example. And that doesn't mean they're incapable of making decisions, because the condition of dementia generally progresses, in a way that's, not good in terms of the person being able to function and so on. But any finding of incapacity has to be tailored to the individual. Other things ruled out. Is it medication? Is it a thyroid problem? What are there other things that could be causing or contributing to their inability to understand or communicate or make decisions? So it definitely has to be individualized. And in the legal construct or term capacity is situation specific. So it's not an all or nothing situation unless the person's in a coma. Somebody might have the capacity, very well have the capacity to make decisions to get their teeth cleaned, or to have an annual medical exam and so on, and yet not have the capacity to make decisions in a very complicated surgery with nuanced pros and cons, benefits and detriments, and so on and so forth. So it's situation specific. And the law presumes capacity unless there's contrary evidence. So we start out with the presumption or assumption that a person has capacity, and if you want to call it the burden of proof, the burden is on the healthcare provider to establish evidence to the contrary if they want to deny that person the right to make decisions. And also the capacity to give consent for a medical treatment is different than the capacity to delegate decision-making through a power of attorney to somebody else. There's very little capacity that's required for someone to know, gee, I might not be able to make a decision, if I'm in a coma or under a drug situation or whatever, but here's who I trust and here's who I want to make decisions for me. That's about all you need to know in order to designate someone as your healthcare agent. Okay, so then effective communications. False assumptions hinder communication. So assumptions really need to be questioned or checked. The patient should be asked about their communication preferences. They may have certain techniques or methods or people that assist them in understanding or communicating more effectively. And so the provider can ask that if it's not offered in advance. A support person should be allowed if requested by the individual. Like I say, images and graphics can be part of the effective communication process, and also providing extra time. Supported decision-making may be necessary to avoid discrimination in medical treatment, to obtain informed consent, to have effective communication, and to offer reasonable modifications of policies. So supported decision-making is considered a reasonable accommodation or modification under federal law now. So it's required to be offered or allowed if requested, unless it doesn't work. And if it's tried and it doesn't work, you can't ask people to do the impossible. But it's time for providers and patients and family supporters to learn more about supported decision-making. In terms of compliance by the providers, if they have 15 or more employees, which most of them do, they have to designate someone on staff to coordinate efforts to comply with Section 504. So I remember we reached out to hospitals and asked for, the name of the compliance officer, and most of them didn't even respond. So hopefully this is something that the hospital association has dealt with, and we just didn't get a response from them, or they'll be reminding providers of this in the future. But it's not just hospitals, because there are many, many clinics and other providers that have 15 or more employees, and it's not a hospital setting. But if they get federal funds, and which most of them do through Medicare, Medicaid, and so on, they have to designate someone. Then there has to be a grievance procedure and notice of non-discrimination. So all covered entities, regardless of the number of employees, have to give patients notice of their policy on non-discrimination in healthcare services. So this is something that all the providers are going to need to take a look at to make sure that their patients' rights policies are in compliance with these federal rules. Then providers with 15 or more employees have to adopt an internal grievance procedure that has due process standards. And that means the ability that if you're just rejected by the clerk typist, who's the first level of complaint, you have the right to appeal the denial of your grievance to somebody higher up in the organization, and that the complaints are processed in a prompt and fair manner. And then in terms of employee training, 15 or more employees, the provider has to adopt written policies and procedures that comply with these new rules, train employees on the policies and procedures, relevant employees. And relevant employees include those who are interacting with patients, which is many of them, but not all of them. There are some behind the scenes. And those who are making decisions affecting the patient's health care, which could be management people. If they're deciding, making decisions that affect health care, then they have to be trained on this too. And then the executive leadership team and legal counsel have to be trained in these new rules. Complaints to the Office of Civil Rights. You don't have to go internally first if you have a complaint and you feel that federal law has been violated. You can go directly with the Office of Civil Rights. But I think best practice and courtesy and common sense is you try to resolve it internally with the healthcare provider before making a federal case out of it. But if you don't get a resolution, you can go to the federal government and file with the Office of Civil Rights. And many times the patient themselves will not be able to file the complaint because of the nature of their disability or their medical circumstance. So someone else can file it on their behalf. And that someone else doesn't have to be a lawyer, because these complaints are considered administrative procedures. They're not court cases, not at this stage anyway. So at the stage where it's just an administrative complaint, the patient can do it, or they can have a lawyer if they want, or a non-lawyer, which could be a chosen friend or family member. So, because without that, many people won't be able to afford a lawyer. And if the patient themselves don't have the ability, then you would have discrimination built into the complaint process. So we can't have that. A complaint process for disability discrimination may not have discrimination built into it. So somebody else has got to be able to file a complaint on their behalf. Finally, complaints if hospitals are involved in Missouri, and if the internal process hasn't worked, then Missouri has a Bureau of Hospital Standards. And Missouri used to have its own regulations on patients' rights. But a few years ago, the legislature and the agency decided to simply incorporate federal patients' rights laws and regulations by reference, and that they would just enforce them at the state level. So that's what that's what the law now is in Missouri. So the Bureau of Hospital Standards, in terms of patients' rights, is enforcing federal law, which means that the staff that process these cases with the Bureau need to become educated about the disability non-discrimination provisions under Section 504 and Section 1557. So that's about it. And I'm going to open up to questions and comments, but more about the Medical Rights Workgroup and alternatives to guardianship can be found on the alternativesToGuardianship.com website, and as well as many, many resources. And I'll just mention that when I do a final report, there'll be a section that will include all of the references and resources that have been developed so far for the work group. So those will be available to everybody, the how-tos, the forms, everything that we've done. And then in the future, hopefully there will be other educational methods that will be used. I know that Jennifer Hume said that she's already working on some short videos about patients' rights. And so, sometime probably in the fall, there'll be additional educational materials that will be available and be used. So anyway, that's about it. And I'm going to get rid of the screen share. And then I think we can open it up to any questions or comments. If anybody wants to jump in, just do so, please.
I just wonder, as a self-advocate, going forward, what can I do to strengthen all of this and to help the people around me and just to improve the future?
Okay.
I do some trainings, but I really would like some feedback and some input on how, as an advocate, that we can help push this forward.
Well, one of the things that I think that you can do is to communicate with the Protection and Advocacy Group for Missouri, and encourage them to let it be known to all of their network that they are available to receive complaints about disability discrimination in the healthcare settings, and to review them and to provide assistance to the ability they have within their budget and staffing. But I think that's something, if they hear from people, and they may already be doing that, but it sure helps to get positive feedback from others that we need you, we want you, and they can play a very important role in resolving a complaint. If a provider is getting a phone call, email, or letter from a disability rights legal services organization, they may pay more attention to it than just from the patient themselves. And so the other thing that you could do is to reach out to the Bureau of Hospital Standards and to encourage them to get training on the new federal rules, and to let it be known that they will process complaints. I think another thing you can do is to reach out to the professional associations, the State Medical Association, Hospital Association, Nurses Association, and so on, Social Workers Association, and ask them to hold some webinars for their members about the new federal rules on disability discrimination by healthcare providers, and to include a self-advocate in their presentations. You could offer yourself if you want, but I know a lot of this is technical, but some of it is just hearing from the patient population directly that can have a good impact. And so those are a few things to start. Eventually, when some of the new materials are being developed in the fall for education around this, then it's letting people know, letting other self-advocates know that these are available, and they should share the materials, share the videos, etc. And some of the materials we already developed that are on the website and that were sent to you before are, it's like some of them are directed to patients, some are directed to family advocates. So you can already start sharing some of those, because I mean, maybe some of it could be translated into even easier language and so on. That's what's in there. But you can start with sharing those materials. And somebody, I forget who it was, sent me something that was being done at a communication level that was more accessible to people with cognitive disabilities. And I'm going to go back and look at that. But when I find it, I'll share it with you. And so it's something that's more tailored for that particular audience. So those are a few things. I mean, it's not earth-shattering, but every one of those things could result in a ripple effect that's going to make, the more educated people are, the less discrimination there will be.
Thank you.
Sarah Wilson, if no one has a question just yet. The which components of the rule are new to developmental disability? Because a lot of the requirements, I mean, to my knowledge, all of them exist currently. So is was this a clarification of that, this applies to individuals with disability, with developmental disability, or is this actual new language that they repeated?
It's a little bit of both. If you go to the report itself, the 32-page report, you'll see the language of some of the language they put in the proposed rule, and then some of the language was added in the final rule. But the language that was in the proposed rule, explaining what it means, is valid unless that part of the rule was not finally adopted. But I included in that report only the things that were in the proposed rule that were eventually adopted in the final rule. So all the language that's in there. Now, you may be thinking, perhaps, I don't know if you're thinking about the Americans with Disabilities Act, and a lot of these same things have been a part of that under Title II for state hospitals, and and then under Title III for public accommodations that hospitals and doctors' offices were considered public accommodations. And many of the same concepts are and have been a part of the ADA. But under Section 504 and 1557, 1557, as you know, is, since it's Obamacare, is new, but it just incorporated a lot of the same stuff. What I found is that, for example, the saying that supported decision-making is something that must be considered and used if feasible as an accommodation, that was never in the old rules. That is brand new. And there are a few places in the explanations of the rule that talk about cognitive disabilities that weren't used before, or developmental disabilities that weren't used before, even though cognitive and developmental disabilities were always a part of disability protections under federal law and rules. So what I find helpful about the new rules isn't so much the language of the rule itself, which is pretty bare bones. It's like a skeleton, but the meat on the bones is the explanation by the Office of Civil Rights about what this means in practical application. So that's where, if you read the 32-page report, you'll see that the particular section of the rule in question might be, a couple paragraphs or a paragraph with a, A, B, C, and D. But then there could be several pages of explanation by the Office of Civil Rights about what that actually means in practice. So that's where I think the value is here, is this is the first time that they've really explained in some detail. Now, this 32-page report summarizes something that I think the actual final rule with comments and explanations, I think it might be 180 pages long. So I went through all of that, because you've got to be like out of your mind if you're going to, or paid really well to read all 187 pages in detail. So what I wanted to do for the benefit of the work group and others in the healthcare industry was to extract those parts of the explanations that seemed the most relevant to this patient population. So the short answer is yes, a lot of this is the same. Yes, some of this is new. I can't tell you exactly which is new or not, but what I can say is these explanations are new and help clarify what the duties are. So it's kind of the best thinking of OCR at the moment about what these rules mean in the present day and age. So I do think that it is beneficial for providers, their lawyers, management, and others to read the 32-page document. They can look at the longer one if they want, more power to you. But, I kind of got a headache after doing that.
I
So
understand.
does that help at all?
Yes, that does. Thank you.
Okay.
Tom, I had a question, a couple of
Yes.
questions. I guess my question is related to the report and also existing law. Like, we know in best practices and evidence-based practices that getting consent and the inclusion of the subject being assessed is obviously a best practice and evidence-based research on that kind of information. But medically and legally, is it mentioned the requirement of getting informed consent from the patient and the inclusion of the patient in an assessment? Is there any mention in the report or in existing law? And how can we find
consent is a part of federal law. It is required. And so the process of getting informed consent, and the law prohibits discrimination, which means you can't just exclude a patient with disabilities because of their diagnosis or disability unless you rule out that they're not able to give informed consent. So it's more by inference, logical inference, that an individualized judgment has to be made about that particular person to say that they're not able to give informed consent because they lack capacity for this particular decision, or for all decisions if they really truly are in a coma or something. So when you connect the dots of all the requirements under the new rules, there would have to be some type of assessment of the individual, which would have to include the individual, about their ability to give informed consent with or without support, because that's a part of the reasonable modifications or accommodation requirement. You can't say somebody lacks capacity and then prohibit them from having the support they need to give the informed consent that they can give with support. So it's you know, when you put all the pieces of the puzzle together from the new rules, there would have to be a decision made involving the person, an evaluation of them. And it would be discrimination to say they lack capacity and then to use a process that isn't scientifically valid. So, you know, I mean, best practices sound very discretionary, don't they? But this is the law. This says that individualized judgments must be made, including the use of reasonable accommodations and modifications, and the assessment has to be on, can they give you informed consent with or without support, not just without support. So I try not to use, I mean, it's okay to use best practices, but let's just put it this way. There should always be a caveat. Best practices must involve obeying the law and following ethics. I mean, that's like the minimum requirement. If you want to go beyond what the law requires, hey, go for it. But at the very minimum, you must obey the law. And the law says non-discrimination, reasonable modifications, individualized judgments, use of supported decision-making if it's feasible. All of that's now part of the new rules.
Great, thank you. And my other question was about trauma-informed practices, supports, and resources. Does it mention anything about that?
No, I don't think so. No, I think that's another whole area that I think that would probably fall more in best practices. But I do know that, I mean, I think that it would be helpful in any trainings of the healthcare profession about who interact with patients with disabilities of any type, that people with disabilities are a much higher risk of abuse of various types than the generic population. And therefore, you know, and that the medical professionals are mandatory reporters. And therefore, there really should be some training about identifying abuse, ruling out abuse. And then if you really want to give treatment to the patient population in a way that is the most effective, then you have to understand your patient population, that many of them are living a life that involves trauma or the after effects of trauma, which can be medical as well as psychological. So I think that's a whole area of education of the healthcare industry that can be improved upon and is necessary.
Okay, I just have one more question. Sorry, I missed the last one, by the way. I'm
Yeah.
hoping there's a recording or something available of the last meeting. Sorry that I missed.
Yeah, I'm not sure.
Last question I had was, this is like the second to our last meeting, right? So we have another meeting in August, I think you said?
Yeah.
So how have self-advocates been included in the project? Have they been interviewed? Are there videos of like their lived experience, and how have they been included in the project?
So there are two self-advocates that are on today, and there was a third who was invited. I think he only attended one meeting, but So basically, the process has been to give them the same materials and the same opportunity to participate, and maybe the Marie or Lori could address that since they're self-advocates.
I think it would be great if we could include in our final report some kind of a video or something about their experience and why it really matters that we have this project. You know, like we wrote it down, but to have the voice of like
Yeah.
for Marie,
Yeah,
I
I
know
think,
she has
you know
very
what,
significant background related to it.
it would be good. I would be happy to have an interview with either one or both of them at the same time on Zoom, and then record it about their experiences with healthcare in general and their experience with the work group, you know, and any suggestions that they would like to make to other self-advocates. That would be good. We could do like a 10-minute video or something that's not too long so that people would be more inclined to look at it, but whatever length it is, I'd be happy to do that. I think it's a good idea. Marie, you had wanted to say something?
Oh, just recently, like I went to the doctor because I had to go for my ear tube, and so like I asked him, he put that one in, the left one, but he didn't put the right one in, and he told me that like because I have lost. Well, I found out because my mom said I have a loss of hearing in both ears, and he said, well, I could do this one, but I can't do this one. And I didn't understand that. So I called the Gold Coast, and Gold Coast said I could do it. But I understand I had like a lot of ear infections and all that. So, but I would like the ear tube in this one because so I wouldn't have ear infections more. But it was lost of communication with the doctor.
Yeah. Okay.
So
I think
I
that's
did,
part of the experience. Like you've been in a rehab. I guess it would be
yes,
good to document the different kinds of things she experiences. And one of them is if she doesn't have a supporter available to attend the appointment, of course,
yeah,
right?
yeah. I
Um,
didn't have anyone. So
anyway, you're saying that's important, right? That
yes,
the doctor listens to you and that you have a
yeah,
supporter there present
uh-huh,
in case they don't, which is
yeah,
unfortunate, right?
yeah. Like for the surgery, I had to have the surgery for my foot because I fell upstairs. So I had I think I had somebody, but it was just really they left, so it was like really scary for me. So then I woke up. No, well, somebody was there, but somebody else. And then I was just wondering if we could have some funding for this project, for more money for the project, so other people could come and go to this meeting. So
Yeah, so I'll talk to Jennifer Hume about it, since she was the one that got the initial funding from the State Developmental Disabilities Council, about maybe follow-up that can be done from our work to have more funding on the educational component
yeah,
about the recommendations that we're making going forward, and how self-advocates can be more effective
yeah.
as they interact with healthcare providers. So we'll see.
Learning more about it. That would be good.
Yeah, I think that, because I think that the interaction with the people with disabilities should be to empower them to be consumers of the healthcare services who are getting the most out of it, and how to go about doing that. And if you feel that there's discrimination, here's what you can do and should do. So I'll talk to her about that to see if there's any possibility of follow-up money from the state council for the next phase of educating patients and families.
Yeah.
Okay.
Did you guys ever talk about like stuff for college too? Not just,
Well, what we talked about college was more about educating the people who are going to college to become doctors and nurses and social workers and so on, and dentists, and that we need to have a better educational process for those students,
yeah,
including self-advocates who are part of the educational process. I can see we're like an hour and 10 minutes into the
Oh.
meeting now, and before we end the meeting today, I wanted to make sure that Emily Johnson is able to talk about the presentation that she made at the annual conference of AADMD about our work group, and maybe how other states might want to replicate it. So is there any last question that we should address before we turn it over to her? Okay, so Emily, I don't know if you want to stop. Should we stop the recording now for this portion of it? So we have that that we can share with